Good morning, Kent Meyer, Traditions Law, with a new Dr. Meyer's prescription for estate planning. Today we're starting a new series, actually. You remember the last several months we talked about powers of attorney. Now we're going to talk about an area that is extremely important and very misunderstood, at least poorly understood for many people, and that is trust administration. You may have a trust, but just because you have a trust doesn't mean that everything happens automatically. Okay? What happens, for example, when one of a wife or husband dies? What kind of administration should occur? So this is something we're going to talk about today. Not doing this can create tremendous problems for surviving spouses and ultimately for heirs. Particular areas of concern are when you have blended families, for example, where you have children from a prior marriage, one or both spouses. Not doing proper administration even at the first death can create problems because most trusts become irrevocable and unamendable as to the deceased spouse's heirs at the first death. And so that has to be considered in trust administration moving forward. Also, there can be real problems with regard to selling property if you don't administer the trust, particularly if it's a joint property, because if you don't remove the name of the deceased spouse from the deed, even though it's in the trust, that can create real problems down the road when you try to sell the asset, particularly if there's a number of years between the first death and the actual sale of the property. Also, if assets are not properly managed at the first death, lost assets can occur, and this can create problems with heirs down the road. Also, there can be unnamed heirs. And so at the first death, you may want to look at, well, who are the actual heirs of this trust and who are actually going to be receiving the property. Now, what should be done at the first death in trust administration? Well, the will should be filed with the county. The original will of the decedent should be filed within 30 days of death. Oftentimes, this is never done. Notices are sometimes sent to the beneficiaries, particularly if the surviving spouse has capacity problems. Also, the creditors of the deceased should be notified. Franchise Tax Board, Health and Human Services, Veterans Affairs, Social Security, and all the credit bureaus should be notified at the first death. In addition to that, you would update the certification of trust that you have, removing the deceased spouse's name from the certification. This would then allow you to then manage the trust as a surviving trustee. Also at the first death, you would be paying the debts of the deceased, that is the surviving spouse. So all of these are actions that need to be taken, often are never taken at the first death. And that can create real problems for you and your heirs down the road. So again, Kent Meyer, Traditions Law.